Hello and welcome to the second lecture, wherein we will be solving previous year questions over the last 10 years, which is 2011 till 2021, from the following topics. We are going to be covering legislature, executive, center-state relations, emergency, federalism, and local self-government. Before we begin with this, it is my honest request to you, in case you haven't already, please watch at least the first 16 minutes of the video before this, wherein we've covered previous year questions on fundamental rights. The first 16 minutes of that video covers the golden rules, covers the logic and inference based techniques, and also certain tricks that you can use to solve polity previous year questions and polity questions in the prelims as a whole. Now let's begin with these. I must also inform you beforehand that there are about 83 questions that we're going to be covering. So this is going to be a slightly longer video than usual. You are always more than welcome to pause the video when the question is displayed, try solving it, and then correlate your answers and check whether your technique or the way you arrived at the answer was right or not in the first place. So let's begin. A broad trend analysis is that these topics, the legislature, the executive, center-state relations, federalism, emergency, and local self-government, are fairly popular. And on an average, you will see about 6 to 8 questions that are asked in the exam, which therefore makes these range of topics fairly important as far as polity in the prelims is concerned. Let's begin with the first question straight away. In 2021, we adopted parliamentary democracy based on the British model, but how does our model differ from that model? We've got two statements before us. As regards legislation, the British Parliament is supreme or sovereign, but in India, the power of the Parliament to legislate is limited. In India, matters related to the constitutionality of the amendment of an act of the Parliament are referred to the Constitution bench by the Supreme Court. You've got your options before you. Is either of the two statements correct, or both of them are correct, or neither of them are correct? You can pause the video and try solving it. And now we look at solving the question. See, the first thing that we must do in a question like this is that we must be very careful, because the devil lies in the details of these questions. They have unnecessarily elongated the length of the question so that candidates get confused. So let us simplify this, and we've talked about the simplification technique in the first 16 minutes of the previous video, so you should definitely have a look at that. But let's try and simplify this option. With respect to law, British Parliament is supreme or sovereign, but in India, the power of the Parliament to legislate is limited. What is this basically talking about? It is talking about parliamentary supremacy. So, the British Parliament has unlimited powers with respect to law, whereas the Indian Parliament has limited powers with respect to lawmaking. Now, we all know that the British system of government is wherein the British Parliament is supreme. That's also because the British government does not have a single written constitution. It has constitutional laws, which basically means several laws have been given a constitutional status, and the power vests with the British Parliament to make any changes to any law as they may deem fit. An advanced explanation to this is that the British Parliament, a law made by the British Parliament, cannot be struck down by the Supreme Court under ordinary circumstances. But that's an advanced explanation you don't have to worry about. What you must know is the British Parliament is undeniably superior because it does not have a single written constitution. So that sort of seems correct. And the power of the Parliament in India is limited in two ways. One, the Parliament cannot make a law which violates basic structure. The Supreme Court can strike it down. And two, the power of the Parliament to legislate on a subject matter of law is clearly enshrined in Schedule number 7 of the Constitution, wherein the Parliament ordinarily can only legislate on the union list and the concurrent list under ordinary circumstances. So it is also in a way limiting the powers of the Parliament. This definitely makes sense. This indeed is the correct option. Now let's come to the second statement. In India, matters relating to the constitutionality of the amendment of an act of the Parliament are referred to the Constitution Bench by the Supreme Court. Now, first things first, the Constitution Bench comprises of a minimum of 5 judges. This is established in the Constitution itself. But look at the first statement. It is saying anything which is to determine the constitutionality of the amendment of an act of the Parliament. An amendment of an act of the Parliament is also a law. So to determine the constitutionality of a law, it can be done by a constitution bench of the Supreme Court. That is not necessarily true. Let's understand why. What happens if there is a constitutional objection to a law? Why is a law considered to be constitutionally objectionable? One simple reason why that could happen is if a law is violating a fundamental right, which is a part of the Constitution, the law is constitutionally objectionable. So if a law is violating if it's violating a fundamental right, it is also technically violating a constitution. And if a law is violating a fundamental right, you can challenge that law not only in the Supreme Court but also in the High Court. And High Courts also have the powers to issue similar writs like the Supreme Court as the court of first instance for fundamental right violations. Not only that, they also have the powers to strike down a law if it is violating the Constitution. Now think about it, think about examples. So in the earlier cases around homosexuality, where the Nas Foundation case was originally filed in the Delhi High Court, the Delhi High Court had actually declared homosexuality to not be criminal anymore. It was the centre who then appealed against this in the Supreme Court, which directed the case back to the High Court of Delhi, which then reversed its own decision. But for a brief period of time, originally homosexuality was perfectly legal within the territory of Delhi because the Delhi High Court had said so. Similarly, earlier cases pre-Kedarnath in the sedition issue actually had declared, in fact, in an earlier case in the Punjab Haryana High Court, before the Kedarnath judgment, the Punjab Haryana High Court had actually declared sedition as unconstitutional. So you could not file a case on sedition in Punjab and Haryana High Court from the delivery of that judgment. It was the Kedarnath judgment wherein the Supreme Court reversed the earlier High Court judgment and said it could be, but only if the speech or the action necessarily instigates violence. So there have been enough sort of contemporary instances, so you can apply the logic that says relate the option to what you see around you. So the second option is wrong, and therefore the answer only has to be A only. Now a lot of you would think it does not mention the word only, so shall we assume only in a situation like this? Yes, absolutely you should. I'm sure a lot of you would think it does not mention that it is only referred to a constitutional bench. No, that's not the hidden meaning behind the question. You have to disregard this. Also, you don't necessarily have to refer it to the constitutional bench. You only refer that matter to a constitutional bench which requires a constitutional interpretation. If it doesn't require, if a provision of the Constitution does not require a constitutional interpretation, ordinarily you don't refer it to a constitutional bench. So the answer to this question will remain, will remain A1 only, as the second option is incorrect. There we go. Let's move to the next question. A constitutional government means what? We've discussed this in our very first lecture on Magna Carta as well. But what is a constitutional government? We'll simply apply the devil's advocate technique, where we'll try to argue the opposite. A representative government of a nation with a federal structure. A constitutional government basically means a government which is bound by the constitution, or there is a constitution to give you the governing principles of the government. A representative government of a nation, which means there is democracy, with a federal character, which means there is democracy and federalism. You can have democracy and federalism without a constitution, so that is not necessarily what it means. A government whose head enjoys nominal powers. Now this would largely mean that there is a republic, because you have what is called a parliamentary system of government. You can have a parliamentary system of government with a republic, in the sense that your head does not have real powers. A parliamentary system of government or a parliamentary republic does not necessarily mean there has to be a constitution. There are several examples in the world, so this also doesn't seem to be right. A government whose head enjoys real powers. Both of these options are contradictory, so this would mean this is basically a presidential form of government. So can you have a presidential form of government without a constitution? Yes, you can. So this is also not the option. What you're left with is option number D, a government limited by the powers of the constitution, or that's what constitutionalism is. It's a theory where you limit the powers of the government through the constitution, and a constitution is a single document that governs the powers in the first place. So a very simple question could be answered in a rather fast manner. So your answer here should be D. There we go. Next question. A tough question. A lot of people got this question wrong last year, but let us see if we could try and solve this question. Okay. Consider the following statements. Statement number 1. In India, there is no law. In India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. In 1991 Lok Sabha election, Shri Devilal contested from 3 Lok Sabha constituencies. As per the existing rules, if a candidate contests in one Lok Sabha election from many constituencies, his or her party should bear the cost of by-elections to the constituencies vacated by him or her in the event of him or her winning in all the constituencies. All right, fair enough. Now, let's look at this question carefully. First things first, in India, there is no law restricting the candidates from contesting from 3 elections. In the 1991 Lok Sabha election, Devilal contested from 3 Lok Sabha constituencies. Fair enough. We would possibly not know the factual detail around 2. Let's focus on statement number 3. As per the existing rules, firstly, you would have a law, you will have an act, not rules, because after all, you're dealing with electoral processes. So this seems to be slightly off. If a candidate contests in one Lok Sabha election from many constituencies, his or her party, which means you're talking about a party candidate, and we understand that an election is not only fought by party candidates, it is also fought by independent candidates. So apply this. If it could apply to a party candidate, it should also apply to an independent candidate. You can't have 2 separate provisions treating party and independent candidates differently. That would be perverse under law. But let's understand this. So, if an independent candidate contested by-elections from the constituencies, if an independent candidate contested elections from many constituencies, then who will pay for the elections for the other constituencies that the independent candidate contested from? Bear in mind, the independent candidate does not have the same kind of financial backing as a party candidate would, because the party candidate would be assisted by the funds allocated to the candidate from the organization of the party that the candidate belongs to. So it seems very unlikely. If you are somebody who does not have any party backing you, and you want to fight elections and you want to make a difference and you want to represent the cause of the people, and you contest from 2, 3, 4, 5 places as per the question, and let us say, you win in all, then you have to pay. You have to choose one seat, then you will have to pay for the elections that have to be conducted for the constituencies that you're not picking. That seems rather unfair. So therefore, option number 3 seems wrong. So this is wrong and this is wrong. We can eliminate them. Now either 1 is correct or 2 is correct. Now they don't seem to be contradictory per se, but think about it. There are 2 problems here. First, how can there not be a law deciding the number of constituencies that a candidate should fight from? So that's one part. 2, think about the recent elections that have happened in the country. Think about, say, where did Rahul Gandhi fight elections from, or think from where did Narendra Modi fight elections from, right? They've usually fought elections from 2 places, which means that if you have to take an educated guess, you know that a candidate can contest from a maximum of 2 constituencies. If it's a Lok Sabha election, from any 2 constituencies all across the country without any residency or domicile requirement. So this means this definitely seems to be wrong. However, there were amendments in 1996 which were actually made to the Representation of People's Act, where we put the limit to 2. But that is something you can't remember. That is something you are not supposed to remember. But what you definitely know is that the Prime Minister of the country had contested from 2 constituencies, right? And of course, a major leader from the opposition party of the country had also contested from 2 constituencies, which means there is a limit of 2 constituencies, and that could be safely assumed. So that is wrong. What you are left with is this, which means there could have, if you just read both the statements together, this means up until a certain point you could contest from 3, but after a certain point you can only contest from 2. So the second option is correct. This particular gentleman had contested from 3 constituencies, and therefore the answer in this particular question becomes your B, which is 2 only. All right, which is only 2. So this is your answer. Now, 4th question. At the national level, which ministry is the nodal agency to ensure effective implementation of the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act of 2006? This is again a question asked in 2021. Now, I am sure a lot of you would have gotten this question wrong, not because the question was tough, because the question seemed too easy to be true. Because a simple way to go about this is, the question mentions tribes, there is the Ministry of Tribal Affairs, don't think twice, just mark D and move on. And then you would think to yourself, again, how can the UPSC ask such an easy question in one of the most competitive exams in the country? So what you could still do is, you can try and eliminate by playing the devil's advocate. Think about it. The Ministry of Environment, Forests and Climate Change, it looks at the protection of the environment of the country as a whole, not just with respect to scheduled tribes. And no doubt their localization of environment is an issue, but it's not the only issue that they have to deal with. So this doesn't seem like the right answer. 2. Ministry of Panchayati Raj, which fundamentally implements the 73rd Amendment. Now, the 73rd Amendment is not even applicable to the 5th schedule, which also contains scheduled tribes. So this does not seem to be the right answer. Then you have the Ministry of Rural Development. Why are you assuming that all of them are are traditionally only in rural areas. If you think about it, there could be certain scheduled tribes in certain scheduled areas which may not necessarily be in the rural part of the country, right? So, for example, that's the problem, right? So, what usually ends up happening here is that you are very easily able to eliminate all of this. Think about it. The Panchayati Extension Scheduled Act is applicable to the 5th schedule. 73rd Amendment is not even applicable. Nothing is applicable to the 6th schedule because they have their own autonomous councils and regional councils. We've covered this also in Magna Carta before. So the only option that you're left on elimination is the Ministry of Tribal Affairs, which happens to be your correct answer, right? Now, let's move to question number 5. With reference to the union government, which of the following statements, consider the following statements and see which of them are correct. All right. Sorry. Okay, again, very tough, because if a question like this comes, firstly, it's not worthy of the pre, but if it comes, you must approach this question with absolute care and absolute caution. And only if you really have to attempt a question like this, should you try and attempt a question like this. If you think you're not crossing the 100 mark, you should try not to attempt a question like this. All right. So with reference to the union government, consider the following statements. First, the Gopalaswamy Iyengar Committee suggested that a minister and a secretary be designated solely for the purpose of the subject of administrative reform and promoting it. All right, let's look at some of the keywords. First is Gopalaswamy Iyengar Committee. Second, suggested that a minister and one secretary be designated solely for the purpose, which means only and only for the purpose of pursuing the subject of administrative reform and promoting it. All right, okay. In the year 1970, the Department of Personnel was constituted on the recommendation of the ARC of 1966, and this was placed under the Prime Minister's charge. All right, this was placed under the Prime Minister's charge, and we're talking about the Department of Personnel. Okay, seems like a tough question. Let us see, what do we know about this in the first place. We know that there is something called the Department of Personnel and Training, DOPT, right? And we know that the DOPT is under the Prime Minister's office. We know that the DOPT is under the Prime Minister's office, right? Now, let us see, how does this work? First option, the Gopalaswamy Iyengar Committee suggested a minister and a secretary be designated solely for the purpose. Let's see, where are the problems here. If you are saying that only and only a minister and one secretary be designated solely for this, that means you have to essentially create either a department or a ministry. Only either a department or a ministry if you're allocating a dedicated secretary and a dedicated minister. Now, have you heard of something called the Department of Administrative Reform? No. Have you heard of a ministry called the Ministry of Administrative Reforms? No. And two, if you are setting up a department or a ministry, you don't have to worry about them promoting it. They're supposed to implement it. You don't promote reform, you implement reform. While the real answer to this is that it was not Gopalaswamy Iyer, but somebody else who had recommended it. But it is beyond aspirants and teachers also, for that matter. Honestly, I did not know who suggested it. So I would have played that game. That it seems too much resource allocation for a very specific subset of the larger issue of administration. Okay? So it doesn't seem very likely. I would have marked it as the wrong option. Now, in the 1970, the Department of Personnel was constituted on ARC recommendation. Fair enough. I don't know when it was constituted. I don't know when it was, on whose recommendation was it constituted. No problem. But sounds like it was placed under the Prime Minister's charge. So sounds like the PMO is in charge, which sounds like a fair assessment to make, because Department of Personnel and Training and Department of Personnel seem very familiar. So it seems like it is essentially about the same department and it is under the PMO. Now, let's understand why this is a controversial question. Because if you see the wording of the question, it says it was placed under the Prime Minister's charge. This was placed under the Prime Minister's charge. Does this mean it was placed under the Prime Minister's charge in 1970 and the system has changed ever since? Or it was placed in 1970 under some other leadership, but the situation is different today? Or it was placed under somebody else's charge altogether? Now, there are several recommendations, there are several resources that say it's under the Cabinet Secretariat as well. So this seems like a little bit of a grey area question. I would have marked the second option as correct and I would have marked B, but I could be wrong. The official key here has not been released yet, and these kind of questions are things that it's okay to not get right. Okay, it's fine. Let's move on. Bad things happen. Okay, so this is the question where the answer seems to be B. Now, question number 6. Which one of the following in Indian polity is an essential feature that indicates that it is federal in character? We've done this extensively. We simply have to apply the devil's advocate theory, argue the opposite. If the opposite seems to be true, then this doesn't seem to be right. So let's start with option B first. The Union Legislature has elected representatives from its constituent units. This sounds like, this sounds the opposite of federalism. It has nothing to do with state legislatures. All that it is saying is that you are a parliamentary democracy. The Union Cabinet can have elected representatives from regional parties. All that it is saying is that you have a multi-party system and people who comprise of parties, even which are not national in nature, can also become a minister. Sounds like you're assisting a coalition government or regional parties for that matter. Again, this has nothing to do with a regional government. So B seems to be wrong, C seems to be wrong. The fundamental rights are enforceable by a court of law. Fundamental rights are for the people, doesn't matter how many layers of government exist. So this also seems to be wrong. The only option that we're left is independence of judiciary. Because if you have center and states, there are going to be disputes and you need an agency to adjudicate these disputes in the most impartial and independent manner. Therefore, independence of judiciary is the right answer. This is an easy question, should have not taken you long to solve it. Question number 7. A parliamentary system of government is one in which all political parties are represented in the government. The government is responsible to the parliament and can be removed by it. The government is elected by the people and can be removed by them. The government is chosen by the parliament but cannot be removed by it before the completion of a fixed term. Now, India is a parliamentary system of government. Just apply these statements to India. Are all political parties in the parliament represented in the government? No, because you have the concept of a government and an opposition. You do not have members of opposition occupying ministerial positions. Can you? Yes. Do you necessarily have to? Absolutely no. So that does not necessarily apply. The government is responsible to the parliament and can be removed by it. This sounds like checks and balances. Yes. The government is elected by the people and can be removed by them. This sounds like direct democracy and parliamentary system is indirect democracy. So no. The government is chosen by the parliament but cannot be removed by it before the completion of the fixed term. B and C sound contradictory. So if the government, if you cannot remove the government before a term, then how are you responsible to the parliament in the first place? What happens to motions of no confidence? What happens to the parliament approving certain crucial legislation that have to be passed? So obviously option number D is also wrong. Your correct answer is B, and that should be right. Question number 8. Consider the following statements. Now see, according to the Constitution of India, this means it has to be explicitly written in the Constitution. A person who is eligible to vote can be made a minister in a state for 6 months even if he or she is not a member of the legislature of the state. According to the Representation of People's Act, again has to be explicitly written, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting an election even after his release from prison. Which of the statements is correct? 1, 2, both 1 and 2, or neither 1 or 2. Let's try and solve it. A person who is eligible to vote can be made a minister in a state for 6 months. Let's try and simplify this. So, any voter can be a minister for 6 months even if you are not an MLA, right? The second part seems to be okay. But any voter means a voter who can also be 18 years of age, because 18 plus is when you're allowed to vote. So technically there is a possibility, according to the first statement, that an 18-year-old can be made a minister for 6 months without being an MLA. That's not the case, because you have to be for you to become an MLA, you can only contest the elections at 25. So you can't make an 18-year-old a minister, because even after 6 months, this person will still not be 25. So this seems to be the wrong option. You have to apply real provisions to the overall provision. Second, according to the Representation of People's Act, a person convicted of a criminal offence, which means a criminal who has been sent to jail for 5 years, is permanently disqualified from contesting elections. If a person has served punishment and even after serving the punishment is not entitled to resume normal life, then what happens to principles of natural justice? What happens to the theory of punishment that once a punishment has been met, a person must be entitled to resume your ordinary life? And think about it, if this was the case, then how would you ever give a chance to the person to come back and live a willful life in society? So both of these seem to be wrong. The correct answer is D. None of the statements are correct. Ninth, consider the following statements. The President of India can summon a session of the Parliament at any place he or she deems fit. The Constitution of India, which means it has to be explicitly mentioned, provides for 3 sessions of the Parliament in a year, but it is not mandatory to conduct all the 3 sessions. There is no minimum number of days that the Parliament is required to function. Which of the following statements is correct? 1, 2, 1 and 3, 2 and 3 only. Now, this question can be done through a very, very simple trick. A very, very simple trick. All right. Let us try and answer this question. Let's look at statement number 2. The statement number 2 is inherently contradictory in the first place. If the Constitution actually provided for 3 sessions, then why would it say it is not mandatory to conduct those 3 sessions? And if the Constitution did, sessions are to be conducted by the houses, would this not violate our golden rule number 3, which is separation of powers, where the House should have the freedom of deciding when the session has to happen? And that's why you have the Cabinet Committee of Parliamentary Affairs who tells the President what the parliamentary calendar for the year should be, right? So that is why, correct? So obviously this is the wrong option. So if this is the wrong option, all we have to do is eliminate whichever has option number 2 here. So if we see this is wrong and this is wrong, now we are left with either 1 is correct or 1 and 3 is correct, which means 1 is definitely correct. The President can summon a session of the Parliament at such place. There is no minimum number of days that the Parliament is required to meet in a year. This can be solved easily through context. Our country has been fighting COVID for a long time, and while we were at the peak of COVID, obviously we did not have a functioning parliament for a long time. We only had the parliament coming in for very brief moments, and they had to be adjourned for a long time, which is why there were talks about can we have an e-parliament or e-hearings of parliamentary committees. And if you had minimum number of days, then you would necessarily have minimum number of days for the parliament as a whole, but that would then be problematic because you've got two houses. You have to determine the exact number of days for both the houses. So definitely this is correct. You cannot mention a minimum number of days. So therefore 1 and 3 is correct. The answer is C. Next question. The Rajya Sabha has equal powers with the Lok Sabha with respect to or in the matter of creating all India services, amending the constitution, the removal of the government, and making cut motions. Amending the constitution is 368. All India services is when you want to create a new IAS, IPS forest, or let's say we're talking about all India judicial services in the recent context. The removal of the government happens through a no confidence motion, and cut motions are essentially used in the budget, wherein you have a policy cut, a token cut, an economy cut, and so on and so forth. Right? Now, think about it. Lok Sabha and Rajya Sabha will have equal powers on things that do not have a federal impact, right? So if you are creating a new All India service, which is to be recruited by the center, removed by the center, but they work at the states, it has a federal impact. So the Rajya Sabha must authorize the same with a resolution. So this is definitely not the right answer. When you're removing the government, which means what we're talking about is that the executive, the council of ministers are collectively responsible to the Lok Sabha. So if the Rajya Sabha had the powers to remove the council of ministers, a representation of the states would have a role to play in the political stability at the center, thereby violating center stronger than the states. Doesn't seem to be the case. And the Lok Sabha, by the nature of it, has a superior position when it comes to the budget. The budget is nothing but an advanced money bill, and the Lok Sabha always has a higher power. Now, therefore, if the Rajya Sabha had the powers to make these cut motions, that means the representation of the states would have a say in the financial policy making of the center, thereby compromising center stronger than the states. So your answer is amending the constitution, because Article 368 says the parliament has the power to amend the constitution. The answer will be 10B. Next, 11. Tough question again. With reference to the funds under the Member of Parliament Local Area Development Scheme, which of the following statements are correct? We must always circle what is correct. MP-led funds must be used to create durable assets such as physical infrastructure for health, education, etc. A specified portion of each MP's fund must benefit scheduled caste, scheduled tribe populations. MP-led funds are sanctioned on a yearly basis, and the unused funds cannot be forwarded or cannot be carried forward to the next year. The district authority, which is basically you as the DM, must inspect at least 10% of all the works under the implementation every year. Now, what are our options? 1 and 2, 3 and 4, 1, 2 and 3, 1, 2 and 4. Let us see if there is something that we can eliminate, and that's very, very important. Let's look at what is common across these 4 options. In 3 options, we have option number 1, and in another 3 options, we have option number 2. So you see 1, 1, 1 here, we see 2, 2 and 2 here, right? So in A, C and D, we definitely see 1 and 2, right? We definitely see 1 and 2. Now, see very carefully. If you see 1 and 2 across A, C and D, which means, and we see 1 and 2 as common here, which means either both 1 and 2 are wrong, or either both 1 and 2 are wrong or both of them are correct. Now, if for both 1 and 2 to be wrong, then your options will only have 3 only, then you'll have 3 and 4 only, right? You will only have 3 and 4 if both 1 and 2 are to be wrong. Let us see if we can prove 1 and 2 to be wrong. MP lads must be used to create durable assets for physical infrastructure, health, education, etc. Sounds fair enough that you are using local area development funds to locally develop the area, and for that you require, say, funds for health, education, sanitation, etc. Which means 1 definitely is correct. Now, if 1 is correct, then 2 is definitely correct. So 1 is correct, then 2 is definitely correct. That means your options 1 and 2, C and D, seem to be in the game so far. There is no place where 3 and 4 are collectively together. Now, either 3 is going to be correct or 4 is going to be correct. Now, let us see. MP-led funds are sanctioned on a yearly basis, and the unused funds cannot be carried forward to the next year. MP-led funds are sanctioned on a yearly basis, and the unused funds cannot be carried forward to the next year. The district authority must inspect at least 10% of all works under implementation. What have you ever heard about carried forward funds? You would have heard of something called the March rush in the budget, that the government, the ministries or the departments have to spend the money allocated to them before the financial year. Otherwise, it lapses, the government takes it back. But this is for funds which the budget has given to the ministries. We are talking about funds which have been given to our MPs or our MLAs. There's this distinct difference. I understand that ministries function on a financial year basis, but what if the ordinary tenure of an MP or an MLA is 5 years, right? And therefore, there could be a case where the work may have not been so much. What if, let us say, take a hypothetical scenario. The elections, now this we all run on a financial calendar basis. Elections to, let us say, like Lok Sabha elections, let us say, happened in January. In February is when, let us say, the MPs took over, right? They got the funds. March is your calendar year. How do you expect them to finish their entire funds in a month? Not possible. So therefore, can be carried forward. In the case of ministries, that is why you have something called an interim budget or a temporary budget, which now you don't require much because budgets get passed before March 31st. So this can be done, right? So this seems to be the wrong option. The district authority must inspect at least 10% of the work. This might seem a little odd, but look at the larger principle. Isn't this rule number 3, intra checks and balances at the grassroots level? So your answer is 1, 2 and 4 because you have eliminated by simple application of rules. A tough question, but if you are patient, if you are calm with it, you may come across the right answer. Next question. Along with the budget, the finance minister also places other documents before the parliament which include the macroeconomic framework statement. The aforesaid document is presented because it is mandated by what? Look at the keywords. Mandated, which means it is compulsory. You have to do this under all circumstances. Long-standing Parliamentary Convention, Articles 112 and 110, Clause 1, Article 113 of the Constitution, provisions of the Fiscal Responsibility and Budget Management Act of 2003. Now, if something is mandated, which means something is compulsory, for something to be compulsory, it must always be backed by some form of law. So the first option is automatically out. Now comes Article 112 and Article 110 and then Article 113. Now think about this. The macroeconomic framework statement sounds like something which we would have thought of recently in the last 10, 20 odd years. This is not something that we would have thought of uh, when we were framing the constitution, because if we had, and it has to be backed by law, there should have been a constitution, that it should have been in the constitution itself. And if you had to add it to the constitution later, it would be with a capital letter next to an article. None of this seems to be the case. This largely concerns money bill, financial bills, and so on and so forth. So both B and C are incorrect. The correct answer is provisions of the Fiscal Responsibility and the Budget Management Act of 2003, right? Read the question carefully. You should be able to answer the question. 13. Again, a question on constitutional government. A constitutional government by definition is a government by legislature, a popular government, a multi-party government, or a limited government. All right. Let's apply the devil's advocate theory. A government by legislature simply means a parliamentary form of government. A popular government means a democratic government. A multi-party government means basically a coalition government. And limited by what? Limited by a law. And what is the supreme law of the country? Constitution. The answer is D. Limited government. Very simple, but can be done. Question number 14. In the context of India, which one of the following is the characteristic appropriate for bureaucracy? This is for you guys. An agency for widening the scope of parliamentary democracy, an agency for strengthening the structure of federalism, a political agency for facilitating stability and economic growth, an agency for implementation of public policy. Okay, an agency for the implementation of public policy. We have to simply apply the counter rule. We have to apply the devil's advocate theory, and this can also be done very easily with a simple application of contextualizing it. So let us see. This seems to be an error here. Just this much is enough. So let's apply the devil's advocate theory. An agency for widening the scope of parliamentary democracy. Widening the scope of parliamentary democracy means more and more people should be participating in elections, and more people should be representing in elections, and more people should enter politics, and democracy must be more inclusive. That's not necessarily the primary function of the bureaucracy, because they are an appointed authority. Remember, the bureaucracy is an appointed authority, not an elected authority. So if you have to widen the scope of parliamentary democracy, you want more people to contest elections, you want more people to be represented in elections, that is to be done through a law. A law is made by the parliament. Doesn't seem like it. An agency for strengthening the structure of federalism. To center the structure of federalism, either the parliament is going to make a law for it, or the judiciary is going to pass a judgment giving the federal units certain powers. Doesn't seem like it. An agency for facilitating stability and economic growth. Now, stability would also mean political stability. That is why the word had to be here. An agency for facilitating political stability and economic growth. Now, this means you have to ensure there are lesser taxes, lesser compliances, single window clearances. You have to make sure there is lesser defection. You have to make sure that you have stronger criminal repercussions for the commensurate political candidates. All of this has to be done by the legislature. What is left is an agency for the implementation of public policy. A seemingly easy question, but I remember in 2020, quite a bunch of the students had gotten this question wrong. Now, question number 15. Consider the following statements. The Parliament Prevention of Disqualification Act 1959 exempts several posts from disqualification on grounds of office of profit. The above mentioned act was amended 5 times. The term office of profit is well defined within the Constitution of India, right? Now, let us see the option combinations. 1 and 2, 3 only, 1, 2 and 3, and 1, 2 and 2 and 3, and 1, 2 and 3. We're able to see option number 2 here, here, and here. In 3 out of the 4 options, we're able to see option number 2. Can we eliminate option number 2? We don't have the required factual knowledge for it. Is there any other option which is in 3 out of 4? We've got option number 3. The term office of profit is well defined in the Constitution of India. Now think about it. If you think about it, the term office of profit is well defined in the Constitution of India. The Parliament Act, the Prevention of Disqualification Act, exempts certain posts, right? Now, to a very limited extent, statement number 1 and statement number 3 seem slightly contradictory, right? On one hand, you are saying the Constitution very clearly defines office of profit, and on the other hand, you are saying there is another law which gives you exemptions to office of profit. Can you define office of profit without mentioning its exemptions? And if office of profit means 2 competing offices of pecuniary gain, how can you be so sure that you are able to cover all offices that may arise in the future? And therefore, office of profit is not clearly defined. So if it is not clearly defined, can I try and eliminate option number 3? Yes, I can. So if I eliminate option number 3, I am left with A, 1 and 2. This is also a trick that we use on option combos. This doesn't seem to work in the last 2 years or so, but it used to work in 2019. So the answer is A. Question number 16. With reference to the Legislative Assembly of a state in India, consider the following statements. The governor makes a customary address to the members of the House at the commencement of the first session of the year. When the legislature does not have a rule on a particular matter, it follows the Lok Sabha rule on that matter. A very, very debatable question and a very intricate question, and it is not your fault if you got this wrong. It's okay, happens sometimes. Let's see the question. The governor makes a customary address to the members of the House at the commencement of the first session of the year. This sounds like a motion of thanks, which is also true for the president at the center. This is definitely correct. We are stuck with the second option. When the state legislature does not have a rule on a particular matter, it refers to the Lok Sabha rule on that matter, right? Now, let us try and simplify this. What we are saying is, for example, your UP Legislative Assembly has something called rules of procedure, right? Now, on a specific issue X, you do not have a rule of procedure on the matter, right? In that scenario, it will follow the Lok Sabha rule on that matter. It does not, the option does not say it has to follow the Lok Sabha rule under all circumstances. It says it follows it on that matter. Now, this could mean that if it wants to, it can choose not to, or it can make its own rule of procedure. You have absolute freedom to make your own rules of procedure, but you haven't. Which means if you haven't made a rule of procedure, this seems to be vacant. Then do you follow a Lok Sabha rule on that matter? The answer is yes, you do follow a Lok Sabha rule on that matter as a matter of fact, because of center stronger than the states. Rule number 2, this is like a hollow candy, that you make your rules. If you don't have a rule on a subject matter, you will have to follow what you should follow, or you may be obligated to follow a rule which is made by the Lok Sabha on a similar matter. Tough question, but here the answer would be C, both 1 and 2. Okay? Yeah. 17. Which one of the following suggested that the governor should be an eminent person from outside the state and should be a detached figure without intense political links, or should have not taken part in the politics in the recent past? We've got the first Administrative Reforms Commission, Rajmanar Commission, Sarkaria Commission, and the National Commission to review the working of the Constitution. Now, think about the context. We're looking at a committee or an organization which would have recommended some major changes to the office of the governor. This has been a major issue, especially around the 70s and 80s when there was the rise of regional parties to a point of no return. 1966 and 1969 seemed too early for us to be worried about the office of the governor. And we definitely have heard of Sarkaria or Punchi commissions as your star commissions with respect to center-state relations. The National Commission to review the working of the constitution does not necessarily fit in because the role of the governor is largely worried about with the aspect of the discretionary powers that they enjoy, which go beyond the constitution. So your correct answer becomes Sarkaria Commission of 1983. Factual question, but could have been done. Next. In India, which of the following review the independent regulators in sectors like telecommunications, insurance, electricity, etc.? So we're basically talking about TRAI, who regulates TRAI, who regulates the Insurance Regulatory Development Authority, and let us say who regulates the electricity regulators, which of course could be state-wise. Now, ad hoc committee set by the Parliament, Parliamentary Department related standing committees, Finance Commission, Financial Sector Legislative Reforms Commission, and the Niti Aayog. Look at the option combinations: 1 and 2, 1, 3 and 4, 3, 4 and 5, 2 and 5. If you're reviewing something, which means there is a sense of accountability, rule number 4, checks and balances. These are all regulators, which essentially means that they are a part of the permanent executive. And for you to review it, you must be a branch of government or you must be a sub-branch of the state as a whole. Let us see, out of all of these, what is the least likely? Niti Aayog, because Niti Aayog is an advisory body. It's like a think tank to the government. It has no real review powers as such. So any option that has Niti Aayog in it automatically gets removed. Now you're left with 1 and 2, which is 1 and 2, and 1, 3 and 4. 1 and 2 or 1, 3 and 4. Which means 1 is definitely correct. So if 1 is correct, which is an ad hoc committee set up by the Parliament, and they can set up a committee on anything, 1 is correct, 2 should definitely be correct, because at the end of the day, these are all parliamentary committees. So Parliamentary Department related standing committee could mean, let us say, a committee on a public accounts committee, which could review the work that they do. So if 1 is correct, 2 is definitely correct. Yes. Now, if you see 3 and 4, the Finance Commission recommends, it is a recommendatory body in the first place. So how can they review the work of somebody else? And similarly, the Financial Sector Legislative Reforms Commission also doesn't make sense because 3 and 4 are given together. So this also gets eliminated because this also again is reviewing, let us say, capital market legislations and laws that are required for the same, such as insider trading and so on and so forth. So your correct answer here would be A, 1 and 2. Rule number 4, checks and balances. Next. Under which schedule of the Constitution of India can the transfer of tribal land to private parties for mining be declared null and void? What you are basically talking about is land use for private gains for mines. 3rd schedule, 5th schedule, 9th schedule, 12th schedule. Let's see what they're about. 12th schedule is about urban local bodies. 9 schedules are about laws that cannot be judicially reviewed. 3rd schedule is about oath. 5th schedule are about scheduled areas, right? Seems like this is the correct answer because you can have some protected land for ecological and systemic regional stability that you can prevent for transfer, which is also why when Panchayati Extension Scheduled Act applies to the 5th schedule, you have additional powers to the Gram Sabha where you would require mandatorily their consultation before any land use has been authorized, right? They also have control over minor minerals produce and forest produce as well. So, 5th schedule. Yeah. The 9th schedule was introduced in the Constitution of India during the Prime Ministership of simple. The 9th schedule, which was added, which bars laws from being judicially reviewed, was added when? It was added in the first constitutional amendment itself through Articles 31A and B, complemented by the 9th schedule. Now, why was this done? Because the landlords had started challenging state land reform laws, which provided a ceiling on the amount of land that they could own, which violated their then existing fundamental right to property, expression and equality. Right to property was, of course, removed as so in 1978 through the 44th Amendment, and that provision under Article 19 Clause 1 Clause F was also removed eventually through the same amendment, but that is the historical genesis. This was done through the first constitutional amendment of 1951. Who was the first Prime Minister of India? Jawaharlal Nehru. The answer is clear as a crystal. So this would be your answer for question number 20. Next, 21. With regards a money bill, regarding a money bill, which of the following statements is not correct? Not correct. Always circle what the question is asking. A bill shall be deemed to be a money bill if it contains only provisions relating to imposition, abolition, remission, alteration or regulation of any tax. A money bill has provisions for the custody of Consolidated Fund of India or the Contingency Fund of India. A money bill is concerned with the appropriation of monies out of the Contingency Fund of India. Money bill deals with the regulation of borrowing of money or giving of any guarantee by the government of India, right? Out of all of this, one seems a slight bit of a contradiction. If you have to go to the parliament to take money out of an emergency fund to meet any last minute urgent expenses, then why do you have an emergency fund in the first place? This is why this on a straight application is wrong. You can take the money out and then later get parliamentary sanction, but at the same time, immediately, you do not need money, you do not need a parliamentary sanction for taking money out of the Contingency Fund of India. So this becomes, C becomes your incorrect option, which is your right answer. Now, with reference to the President of India, consider the following statements. We've done this through a presidential election also in our Magna Carta lectures. Lectures 6.1 and 6.2. The value of each MLA varies from state to state. The value of the vote of MPs of the Lok Sabha is more than the value of the votes of MPs of the Rajya Sabha. Which of the following statements are correct? Now, the value of the vote of each MLA varies from state to state. This is nothing but proportional representation. A UP MLA's presidential election vote will be counted more than the MLA of Arunachal Pradesh because UP has more population than Arunachal Pradesh. This seems to be the correct option. The value of the vote of MPs of the Lok Sabha is more than the value of the vote of MPs of the Rajya Sabha. Now, all elected members of the Lok Sabha and the Rajya Sabha vote, and all of them vote on the basis of the total votes which have been sent to the center by the MLAs, and therefore the total vote value remains the same, which if I remember correctly is 708. So both of the statements are correct. The answer is C, both 1 and 2. All right. The answer here should be C, both 1 and 2. Because the value of the vote is, so this is wrong, both of the values are the same, so the second statement is wrong. So the correct answer will only be A, because Lok Sabha and Rajya Sabha MP votes are the same. They're counted the same number of times. This says it's more, so the answer will only be A. I'm sorry, pardon my mistake. All right. Question number 23. Consider the following statements. In the first Lok Sabha, the single largest party in the opposition was the Swatantra Party. In the Lok Sabha, a leader of opposition was recognized for the first time in 1969. In the Lok Sabha, if a party does not have a minimum of 75 members, then its leader cannot be recognized as the leader of the opposition, right? Its member cannot be recognized as the leader of the opposition. Let us see if we can try and solve this question right. Okay. We've got 3 common across all. We've got 3 as an option, which is here also, here also, here also. Can we try and eliminate option number 3? In the Lok Sabha, if a party does not have a minimum of 75 members, its leader cannot be recognized as the leader of the opposition. Okay. If the Lok Sabha has about 545 members, let's say it's 543, and you have, if you don't have a minimum of 75 members, right? 75 members, then your leader cannot be recognized as the leader of the opposition. 75 out of 543, right? 75 out of 543. This seems like too big of a number, and we will usually, if you think about it, where else have you seen these proportions? You would have heard of 1/10 of the members to be present for quorum to work, right? Everything in the Lok Sabha works on the concept of majority, which is a fraction. You require more than 50% of the total strength to form government. You require more than 50% of present and voting for simple majority. You will never see numbers in a parliamentary democracy. You will never see numbers. Think about it. What if elections happen and let us say a large number of MPs are disqualified? Then will this ratio still seem okay? It would not. So I might not know the technical details here, but this certainly seems odd, and therefore I will eliminate this as the incorrect option. Automatically what I would be left with would be 2 only, right? And if you think about it, option 1 and 2 sound a little conflicting. If the single largest party in the opposition was Swatantra Party, that means you're recognizing a large opposition party, but then you will recognize leader of opposition much later, right? If you think about it, yes. So it definitely, this doesn't seem to be quite convincing. But 3 definitely seems very, very odd. So we'll remove 3. What we are left with is option number 2. And that is how we will arrive at the answer. A basic option combo method. Question number 24. Consider the following statements. The Parliament of India can place a particular law in the 9th schedule of India. The validity of a law placed in the 9th schedule cannot be examined by any judgment or by any court or any judgment cannot be made on it. Now, this question is a simple question that you could have done from your understanding of the Kesananda case and the Minerva Mills case, and then of course later cases also, right? So let us see how we could do this, right? Let's see. The Parliament of India can place a particular law in the 9th schedule of the Constitution of India. Of course it can. They have been doing so since eternity. It is the Parliament who can do that because the 9th schedule is a part of the Constitution. Any additions that have to be made to the Constitution has to be made through a constitutional amendment. And who has the powers to make those changes to the Constitution? The Parliament. Therefore, A is definitely correct. The first option is definitely correct. The validity of a law placed in the 9th schedule cannot be examined by any court and no judgment cannot be can't be made on it. This was actually done through a very, very important Supreme Court judgment. This was done after Minerva Mills, where the judgment now very clearly says if there is a law in the 9th schedule and the 9th schedule law is violating, let us say, what is called basic structure, then in that scenario, that law can be challenged on the grounds of it violating basic structure, and that is perfectly okay. That can definitely be done, and this is the IR Coelho case. In the IR Coelho case, it was decided that a law doesn't matter when it was placed in the 9th schedule, its constitutional validity could be challenged on the grounds that it violates basic structure. In Kesananda Bharti, it was anything after 1973, even if it is placed in the 9th schedule, their constitutional validity could be challenged. So the second option is wrong, the first option is correct. So A only, A1 only is your correct answer, right? Next, 25. Consider the following statements. The Speaker of the Legislative Assembly shall vacate his or her office if he or she ceases to be a member of the Assembly. Whenever the Legislative Assembly is dissolved, the Speaker must vacate their office immediately. Now, see this question carefully. If the Speaker is no longer an MLA, then you are no longer a Speaker. Sounds fair enough, because this is rule number 1, democratic mandate. You do not have the right to. So definitely this is correct. You are violating rule number 1, which is democratic mandate. Whenever the Legislative Assembly is dissolved, the Speaker shall vacate his or her office immediately. Immediately is the key word. If you will vacate the office immediately, then you would create what is called discontinuity in the office. You are just there to hand over the earlier Legislative Assembly to the pro tem Speaker, who will then conduct the elections to the new Speaker. Power must always be transferred from X to Y. So unless there is an X, there cannot be a Y. So therefore, this is incorrect. The option is A, 1 only, right? Okay. Next, with reference to the Parliament of India, which of the following parliamentary committee scrutinizes and reports to the House whether the powers to make rules, regulations, sub-rules, bylaws, etc. conferred by the Constitution or delegated by the Parliament are properly exercised by the executive within the scope of such delegation, right? Very complex statement. Let us simplify this statement. The question is, which parliamentary committee scrutinizes and reports to the House on what? The powers to make rules, regulations. Basically, who gets to decide whether delegated legislation is being implemented properly or not? Is the executive having a field day with delegated legislation and taking their powers a little too far? Delegated legislation is that there is a law which allows you to create certain rules, and the rule should not violate the broad essence of the law. Motor Vehicles Act, Motor Vehicle Rules, Mine and Minerals Act, Mine and Minerals Rules, Right to Education Act, Right to Education Rules. The rules are nothing but technical specifications. They are subordinate. There you go, subordinate legislation. So your answer should be Committee on Subordinate Legislation. Rules Committee would refer to the rules of the House. Business advisory would be what the House should be doing. Government assurances should be what is the government promising and how far are they delivering. The answer here should be Committee on Subordinate Legislation. There we go. Consider the following statements. Let's look at next. No criminal proceedings shall be instituted against the governor of a state at any court during his term of office. The emoluments and allowances of the governor shall not be diminished during the term of his office, right? Very good question, very conceptual, but very, very good question. Now, no criminal proceeding shall be instituted against the governor of the state during the court. Yes, till the time of the governor. For professional actions, you have absolute criminal liability. For personal actions, you have criminal immunity till the time that you're in office. After you're no longer in office, criminal actions can be taken against you. So this is definitely correct. The emoluments and allowances of the governor shall not be diminished. Okay, what do we know about this in the context of the president? This is true for the president because this is charged to the Consolidated Fund of India. Similarly, a governor's emoluments would be charged to the Consolidated Fund of the state. So if it's true for the president, it will always be true for the governor. In most cases, both the statements are correct. C, 1 and 2. Next. If the President of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state, then what happens if 356 is exercised? The assembly of the state is automatically dissolved. The powers of the legislature of the state shall be exercisable by under the authority of the parliament. Article 19 is suspended in that state. The president can make laws relating to that state. We've done this on the implications also. So let us see. Article 356 is nothing but state emergency, right? Article 356 is nothing but state emergency or a presidential rule. We know the grounds: failure of constitutional machinery, no fault of the citizens, so no fundamental right has to be violated. Assembly of the state is automatically dissolved. Powers of the legislature shall be exercised under the authority of the parliament. The president can make laws relating to that state. Now think about this. If the first statement was correct, and they're all contradictory in nature, then automatically there shall not be an option, but somebody else will have to take over. And for the assembly to be automatically dissolved, that means doesn't matter what kind of an emergency is or how serious the emergency is. If there is a presidential rule, then automatically you're dissolving the state legislative assembly. This could mean that this could be abused to a very, very wide degree of proportion. This means every time the center is unhappy with the political party at the state, they could quickly shut them out by dissolving the assembly. That would therefore be detrimental to the interest of democracy and federalism. So this definitely is not true. It may be dissolved on certain cases, but not as a matter of right. Now you are left with 2. Powers of the legislature shall be exercised by or under the authority of the parliament, and the president can make laws relating to that state. Now, this is lawmaking power. Lawmaking power can only transfer from legislature to legislature and then can be transferred to somebody else, and that is why option number B is correct. The powers shall be exercised under the authority of the parliament, right? That is definitely true because democratic mandate. The answer is B. Out of the following statements, choose the one that brings out the principle underlying the cabinet form of government, right? An arrangement for minimizing the criticism against the government whose responsibilities are complex and hard to carry out to the satisfaction of all. A mechanism for speeding up the activities of the government whose responsibilities are increasing day by day. A mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. A device for strengthening the hands of the head of the government whose hold over the people is in a state of decline. Okay, let's try to simplify this and let's try to come to the answer. Not a tough question, but an unnecessarily complex question, right? Let's look for abstract words. Let's look for rather emotional arguments. An arrangement for minimizing the criticism against the government whose responsibilities are complex and hard to carry out to the satisfaction of all. So what you're basically saying here is that a cabinet form of government wherein you basically have ministers is to essentially ensure that just because you have ministers, we will be able to reduce criticism because the government is doing an oh so hard a job. Nope. A mechanism for speeding up the activities of the government whose responsibilities are increasing day by day. All right, possible. a mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. Definitely sounds like a good idea. A device for strengthening the hands of the head of government whose hold over the people is declining is in a state of decline. So we have ministers to support the PM because the PM is not able to control the people anymore. So we need ministers to do that for the PM. That goes against the very essence of government in the first place. Now you're left with option B and C. If you had to speed up the activities, then why would you have 10 ministers, right? That would essentially make things slower because you'll have 10 different departments to go through. So your answer would be C, a mechanism of parliamentary democracy for ensuring collective responsibility of the government to the people. Apply this to what do you know about president of accountability? Council of ministers are accountable to the Lok Sabha collectively. So this would be your answer. Next, the main advantage of the parliamentary form of government is that the executive and legislature work independently. That's not necessarily the case. It provides continuity of policy and therefore is more efficient. The executive remains responsible to the legislature. The head of the government cannot be changed without election. Right, now let's look at this. Argue the opposite. The executive and the legislature work independently. This is actually a feature of a presidential form of government. It provides continuity of policy and is more efficient. Usually presidential systems are more efficient, and doesn't matter what form of government, continuity of policy is very subjective. The head of the government cannot be changed without election. That's actually not the case. You can change the head of the government without election because you are not electing the head of the government. You are electing the head of the government in a presidential election. And in India also, if the president dies, if the prime minister dies, who is the head of the government in a parliamentary democracy, you don't necessarily have re-elections. You don't. You then select the next prime minister because the party still has majority in the Lok Sabha. Your answer would be C. The executive remains responsible to the legislature. Next. With reference to the Parliament of India, consider the following statement. A private member's bill is presented by a member of Parliament who is not elected but only nominated by the President of India. Recently, a private member bill has been passed in the Parliament of India for the first time in history. Okay. Which of the following statement is true? So, a private member is anybody who is not, any MP who is not a minister is a private member. You do not differentiate between elected or nominated members in terms of the bills that can be presented because that would be violating democratic mandate. This is wrong. Recently, a private member bill has been passed for the first time. This is 2017. Recently would be say 2010. So you're saying from 1950 to 2010, and say the first elections happened in 1952, ever since not a single private member bill has been passed. In fact, what do we know? That private member bills are decreasing since history. They used to be passed before but not anymore. So this statement is also wrong. The answer should be D, neither 1 or 2. Yeah. The Parliament of India exercises control over the functions of the Council of Ministers through. This is nothing but rule number 4, checks and balances. How do you keep a check on the ministers? Adjournment motion. This is where you are changing the agenda of the day to ensure that something more urgent is being discussed, which the government doesn't want to. 2, question hour, which is when you are questioning the ministers, and 3, when you're asking follow-up questions to existing questions. Now, I know some of you may get confused that adjournment motion is only in the Lok Sabha, but this is generally spoken of in the general sense of the word. So when you are stopping the government to discuss the agenda that they had set on the floor of the House through an adjournment motion. That definitely is a check and balance on the ministers. In the Lok Sabha is a part of the parliament. When you're questioning ministers for decisions and policies, when you're following up with questions, the answer is D, 1, 2 and 3. This is a very, very simple question. You don't have to think twice about this. Consider the following statements. In the election for Lok Sabha or State Assembly, the winning candidate must get at least 50% of the votes polled to be declared elected according to the provisions laid down in the Constitution. This means this has to be specifically mentioned in the Constitution. The Speaker's post goes to the majority party and the Deputy Speaker's goes to the opposition. This is to be categorically written down. The Constitution does not mention majority party or opposition in the first place. So this can't be true. This may be done by convention but not by a constitutional force. And second, this violates the first past the post system, which is how our lower house elections happen, where you require more votes than everybody else and not most amount of votes. So both of these are incorrect. The answer would be D. Very simple question again. For election to the Lok Sabha, a nomination paper can be filed by anyone residing in India, a resident of the constituency from which the election has to be contested, any citizen of India whose name appears in the electoral roll of a constituency, or any citizen of India. Apply the devil's advocate theory. Anyone residing in India would mean citizen plus foreigner. Citizen of the a resident of the constituency from which the elections have to be held. This means citizen / foreigner, but resident, both seem to be wrong. Any citizen of India whose name appears in the electoral roll. If your name would be in the electoral roll, only and only, only and only if you are eligible to vote, but we'll come to that. And any citizen of India. Now your option is any citizen of India. This any citizen of India could be of any age also, right? This could be of any age. Below 18 also is a citizen of India. So your least objectionable answer becomes C, right? Electoral roll. A citizen of India whose name appears in the electoral roll. Clear? Now any citizen of India could mean anybody who also has a criminal background, etc., etc. This was in fact a slightly controversial question because it was very open-ended, but the answer to my mind should be C. Yeah. Next, which of the following are not necessarily the consequences of the proclamation of presidential rule in a state? Again, a similar question. Are not necessarily, which is not necessarily the consequences of the proclamation of presidential rule in a state. So let's understand what should our answer be. Dissolution of the state legislative assembly, removal of the council of ministers in the state, dissolution of local bodies. Look at the options 1 and 2, 1 and 3, 2 and 3, 1, 2 and 3. Let us see if there is something that is in all the three. We see 1 in 3 options, we see 3 in 3 options. Is not necessarily dissolution of the state legislative assembly, not necessarily the case. Now let's look at the next one. So we see 2 also here, removal of the council of ministers, not necessarily the case. You may or may not remove. Right? Now look at the third option, dissolution of the local bodies. Dissolution of the local bodies have nothing to do with imposition of state emergency, right? Because this is strictly under the aegis of the state government, right? So this cannot be the case. That is what we might think. That is not necessary. So definitely it does not lead to the dissolution of the of local bodies. It's not necessary. It's not going to necessarily affect Gram Sabha dissolution. What do we know? We definitely know it is because of the failure of constitutional machinery. The executive was primarily responsible. We definitely suspend the executive. That means this is definitely what is going to happen. So any option which has 2 should be removed. This is gone, this is gone, this is gone. You're left with 1 and 3, because failure of the constitutional machinery, a legislative assembly may not necessarily be dissolved, but the executive would necessarily be suspended. So that is your option. This is not necessarily, this is necessarily. This is a sure shot implication of Article 356. All right. Now, third is the answers B. Let me check. Yes, it is B. Now, 36. Which one of the following is not a feature of the Indian federalism? Okay. Is not a feature, we must keep that in check. There is an independent judiciary in India. Powers have been clearly divided between the center and the states. The federating units have been given unequal representation in the Rajya Sabha. It is the result of an agreement amongst the federating units. Now, is there an independent judiciary? Yes, there is. Powers have been clearly divided between center and states. Yes, schedule number 7. Federating units have been given unequal representation. Yes, UP has more Rajya Sabha seats than, let us say, Goa for that matter. It is the result of an agreement between amongst the federating units. No, that is not the case. That's what happened to the US. So this is wrong. A simple elimination, because the 3 are more appropriate than the 4th. The answer to this would be D. Yeah, 37. Local self-government can be best explained as an exercise in federalism, democratic decentralization, administrative delegation, and direct democracy. Now, local self-government includes all the 3 layers. Now, let us see. Federalism is between center and states. Local self-government is empowering grassroots populations within a state. No. Administrative delegation happens again from center to states, and this is not just about administration, this is about legislative and financial and other forms of empowerment. So this is not the case. Direct democracy does not happen at all the 3 layers. So therefore your answer is democratic decentralization. Remember, I've discussed this. Devolution is our dream. Decentralization is our reality. Your answer would be B, democratic decentralization. Yeah. Which one of the following statements is or are correct? A bill pending in the Lok Sabha lapses on its prorogation. A bill pending in the Rajya Sabha which has not been passed by the Lok Sabha shall not lapse on the dissolution of the Lok Sabha, right? Shall not lapse on the dissolution of the Lok Sabha. Okay. Now, apply simple rule number 1, democratic mandate. You should be able to answer this. A bill pending in the Lok Sabha lapses on its prorogation. What does prorogation do? Prorogation ends the budget, monsoon and winter sessions. It does not change the composition of the Lok Sabha in any form. So, therefore, this is incorrect. So, this is wrong. Now, a bill pending in the Rajya Sabha which has not been passed by the Lok Sabha shall not lapse on the dissolution. This means the bill originated in the Rajya Sabha, is currently pending in the Rajya Sabha, has not reached the Lok Sabha at all. If it has not reached the Lok Sabha's opinion or view or mandate has not been taken into account. The Rajya Sabha is a permanent house. They can continue to discuss it for as long as they want to. When the new Lok Sabha comes, they can take it up once the Rajya Sabha has passed it and sent it to them. At no point of time the original Lok Sabha has looked into the bill under any circumstances. If they had, then they would have passed it and then sent it to the Rajya Sabha, right? So that has not happened. Their mandate has not been taken into account. So this is the correct statement. The answer will be B. Very simple application of democratic mandate. The Parliament of India acquires the power to legislate on any item in the state list in the national interest if a resolution to that effect is passed by the. Now, if you are acquiring the power to legislate on something in the state list, which means the Rajya Sabha will have to provide some authorization because of rule number 2, center stronger than the states. So any option which has Lok Sabha, you don't even have to read the option. Rajya Sabha by a simple majority of its total membership and Rajya Sabha by a majority of not less than 2/3 of its members present and voting. Now you are legislating here, right? If you are legislating, which means you're legislating on something which the states could have originally done so. So you're transferring legislative function. Now, if that's the case, then your answer would be D, a majority of not less than 2/3 of its members present and voting. Okay. However, if the states are requesting, then they are themselves transferring legislative power, that would require simple majority. Here you would require special majority because the Rajya Sabha is doing so. So by special majority of 2/3 present and it's more voting, in such a way it's not more than half of the total members. So D. Question number 40. Tough question because this also stumped a lot of the people who wrote the exam in 2016. The chief secretary in a state is appointed by the governor of that state. The chief secretary in a state has a fixed tenure. Which of the following statements is or are correct? Now, a fixed tenure means you cannot be removed beyond a certain term. Let's understand who the chief secretary is. Usually the chief secretary is All India Services, which is usually IAS. The chief secretary in a state is appointed by the governor of that state, right? The chief secretary in a state is appointed by the governor of that state. The chief secretary in a state has a fixed term that the chief secretary will serve an X number of years. If that was the case, every time the governments changed, we could change the chief secretaries along with it because you would want people that you like to work with you, right? Because you're the head of the state bureaucracy. So definitely does not have a fixed tenure. The second option is wrong. Now comes the first option. The chief secretary in a state is appointed by the governor of that state. Now this is where things get very, very complex or slightly difficult. The answer is no, it is not appointed by the governor. The chief secretary is usually appointed after approval from the center and of course on advice of the state, right? It is never just a governor decision. It can never just be a governor decision, right? So let us say center, let us say special states such as Delhi, there would be different provisions, and also for other states. So both the options are incorrect. The answer should be D. Okay. Yeah. With reference to the Gram Nyayalaya Act, which of the following statements is or are correct? Now, as per the Act, Gram Nyayalayas can only hear civil cases and not criminal cases. The Act allows social activists as mediators or reconciliators. We understand that the Gram Nyayalayas are nothing but extremely lower courts in the formal judicial hierarchy, which means if they are lower courts, they are not arbitration or mediation mechanisms. So when there is no question of a mediator or a reconciliator, it does not matter who you are choosing to be. So the second option is definitely wrong and can hear only civil and not criminal cases. If it is a court in the formal judicial hierarchy, they can hear both kind of cases. Both the statements are wrong. The answer should be D, neither one or two, right? The option should be D, neither one or two. Okay, now consider the following statements. The minimum age prescribed for any person to be a member of the panchayat is 25 years. A panchayat reconstituted after premature dissolution only continues for the remainder period. Yes, if it is reconstituted with more than 6 months pending. This is clearly mentioned in the constitution. Minimum age to be a sarpanch. Now this is the problem. The minimum age to be a sarpanch would be 21 and not 25. 25 is Lok Sabha and assemblies and so on and so forth. So the first option is incorrect. The second option is correct. The answer should be B, 2 only. Next, there is a parliamentary system of government in India because the Lok Sabha is elected directly by the people. Is that what makes us parliamentary? Then the parliament can amend the constitution. The Rajya Sabha cannot be dissolved. The council of ministers is responsible to the Lok Sabha, right? Now let us argue the opposite. The Lok Sabha is directly elected by the people. That could also be the case in a presidential system of government. The Congress, the lower house in the US is directly elected by the people. That does not make US a parliamentary system. So this is of course wrong. The parliament can amend the constitution. That has nothing to do with the parliamentary system of government. Even in the US, The US Parliament, the US Congress can amend the US Constitution. So not the case. Not necessarily parliamentary. Rajya Sabha cannot be dissolved. So let us say the Council of States cannot be dissolved. Does that make them a parliamentary system of government? No. It works on the system of checks and balances, where the Council of Ministers are actually collectively responsible to the lower house, which is the Lok Sabha. The answer would be D for question number 43. 4. Question number 44. Consider the following statements. The Legislative Council in a state can be larger in size than that of the Legislative Assembly, larger than half in size than the Legislative Council of a state in India can be larger in size that half of the Legislative Assembly of that particular state. The governor of the state nominates the chairperson of the Legislative Council of that state. All right. Nominates, and what you're here saying is state legislative councils can be half of the size, of the state legislative assembly. We know that they can't be more than 1/3, because this half arrangement makes sense for Lok Sabha and Rajya Sabha. This is how the second houses of the states are also lower in quantity than the center. So the first is wrong. The governor nominates the chairperson. A nomination to the presiding officer of a house is democratically blasphemous. Cannot happen. Both of them are incorrect. The answer should be D. Yes. 45. With reference to the union government, consider the following statements. The Department of Revenue is responsible for the preparation of the union budget that is presented to the Parliament. No amount can be withdrawn from the Consolidated Fund of India without the authorization of the Parliament of India. All the disbursements made from the public account also need authorizations from the Parliament of India. Very good question, because it checks your basic principles of democratic mandate and parliamentary democracy. Read the question very, very carefully and see if you can answer this. The Department of Revenue is responsible for the preparation of the union budget, right? Now, no amount can be withdrawn from the CFI without authorization from the Parliament, and all disbursements also need authorization from the Parliament of India. Okay. Now, budget is usually how you spend money. It's essentially a money spending exercise. So would you not have the Department of Expenditure? If definitely not the Department of Revenue, maybe some other department, but definitely not the Department of Revenue. So first option is incorrect. So anything which has first goes wrong. Now you have 2 and 3. 2 and 3 and 2 only, which means 2 is definitely correct, which is also true because of democratic mandate. You can't spend money out of the people's money without authorization from the People's Parliament or the People's Representatives, which is the Parliament. All disbursements made from the public account also need authorizations from the Parliament of India. The public account is money which is kept in the account which belongs to the people directly, Provident Fund, etc. So if money belongs to the people directly and the money is managed by the executive, why do you necessarily need parliamentary authority? You don't. So the answer is C, 2 only. So when a simple example, public account of India contains your Provident Fund. If Provident Fund has to be paid, do you require the Parliament to pass a law for it? Obviously no. So the answer is C, 2 only. Okay. The answer is C, 2 only. 46. When a bill is referred to a joint sitting of both the houses of the Parliament, it has to be passed by a simple majority of members present and voting, 3/4, 2/3, absolute majority. We know that absolute majority does not exist. There's nothing called absolute majority to pass something singularly does not exist. 3/4 as a concept does not exist. 2/3 of the majority of the houses and simple majority only. So constitutional amendments are the only laws which require a 2/3 majority. Everything else can be passed through a simple majority. And constitutional amendments cannot be referred to a joint sitting, which means they're only going to joint sittings are only going to be looking at ordinary laws, and ordinary laws only require simple majority. The answer will therefore be A. A simple correlation question. 47. The Rajya Sabha has no power either to reject or amend a money bill. The Rajya Sabha cannot vote on demand for grants. The Rajya Sabha cannot discuss the annual financial statement. Right? There has been a little bit of confusion with respect to this because your standard textbooks are not particularly clear on this. Okay, so let us see. What is definitely true, right? What is definitely wrong here? The Rajya Sabha cannot discuss the annual financial statement, which is the budget. The Rajya Sabha definitely can discuss the budget. So C and D are out. Now you're left with A and B. That the Rajya Sabha has no power to reject or amend a money bill. They only can give suggestions. That definitely sounds all right. Okay. Now, the Rajya Sabha cannot vote on the demand for grants because, so in the first case, even if they amend, it has to be then approved by the Lok Sabha. So they don't have any finality powers of amendment as such. They cannot reject it. They have to necessarily, they have to give suggestions, but they cannot reject it, right? So the first statement is wrong. The Rajya Sabha cannot, so the first statement is correct. The Rajya Sabha cannot vote on the demand for grants. Demand for grants is nothing but the amount of money that has to be paid from the Consolidated Fund of India to the ministries for their spending, right? Now, if the Rajya Sabha had a say in the voting here, that would mean a representation of the states would get to decide how much money the ministries are getting, right? And that would obviously question center-state relations. So yes, both 1 and 2 are correct. They vote for the budget as a whole, but not specifically for demand for grants. The answer should be B, 1 and 2. Yeah. Consider the following statements. The executive power of the union rests with the Prime Minister. The Prime Minister is the ex officio chairperson of the Civil Services Board. Now, factual question, some of you may know it, some of you may not know it. Executive power lies with the Prime Minister. This is standard format, basic school stuff. The first statement is definitely correct. The Prime Minister is the ex officio chairperson of the Civil Services Board. Now think about it. The Prime Minister anyways heads the Department of Personnel and Training, which manages your All India Civil Services and the civil services as a whole and general administration. Why would you make this person the chairperson of the Civil Services Board as well? Now, if this is the board, like think about who else. You would have heard of something called the Railway Board. Is the Railway Minister the chairperson of the Railway Board? Or for example, you would have heard of the Income Tax Board. You would have heard of the Central Board for Direct Taxes. Is the minister ever a member? Is the chairperson of that board? No, a bureaucrat usually is. So this is also wrong. So this is wrong. So therefore, your answer here should be, so this is wrong and this is also wrong because the executive power is with the president and not the Prime Minister. First statement is wrong. Second statement is wrong. Both the statements are wrong. Therefore, the answer is D. Okay. Now 49. Provisions in the 5th and the 6th schedule are made in order to protect the interest of scheduled tribes, determine the boundaries between the states, determine the powers, authority and responsibilities of panchayats, protect the interests of all the border states. Now, see, protect the interests of scheduled tribes, determine the boundaries between states is Schedule 1. Powers and authorities and responsibilities of panchayats is Schedule 11. Protect the interest of all border states. There is no specific schedule for the same. The only thing that you're left with is protect the interests of scheduled tribes. Simple elimination. You can't go wrong with a question like this. The fundamental object of Panchayati Raj is to ensure which of the following? People's participation in development, political accountability, democratic decentralization and financial mobilization. Alright, let's look at the fundamental objective. Let's try and see if we can eliminate certain options based on option combos. You've got 1, 2, 3, 2 and 4, 1 and 3, 1, 2, 3 and 4. So we see Now this becomes difficult because in 3 options we have 1, in 3 options we have 2, and in 3 options we have 3. So it almost becomes very, very difficult to apply the option elimination technique on option combos, right? Now let us see political accountability, right? Democratic decentralization is definitely the case because that's the objective. So 3 definitely has to be there. Political accountability seems to be a little bit of a problem because that doesn't seem to, because you are not through Panchayati Raj, you are not making the politicians your MPs or MLAs accountable to anybody, right? Here you're building a government of the people, for the people, by the people, from within the people at the community level. So this definitely doesn't seem the case. Financial mobilization will depend on the will of the people, right? And financial mobilization would mean moving of money from A to B. Here we are talking about giving more financial powers to panchayats if the state wants to. So 2 and 4 definitely seem to be wrong. Democratic decentralization and people participation sounds undeniably true. So anything which has 1 and 3 must definitely be correct, right? So 1 and 3 is definitely correct. And if you eliminate 2 and 3, you are left with 2 and 2. So if you eliminate 2 and 4, it becomes, your answer becomes 1 and 3, right? Clear? So your answer should be C, 1 and 3. Simple question though. All right. Yeah. Consider the following statements regarding a no confidence motion. There is no mention of a no confidence motion in the Constitution of India. A motion of no confidence can only and only be introduced in the Lok Sabha only. Yeah, very good question actually. A motion of no confidence can be introduced in the Lok Sabha. That is absolutely undeniably correct. There is no mention of a no confidence motion. A motion is a parliamentary procedure. No parliamentary procedures per se are mentioned except the motion of thanks in a defined entity, right? All that it says is if the government loses majority or loses the confidence of the House, but nowhere does it mention no confidence motion as a term in the Constitution. So no doubt both the options are absolutely correct. The answer should be C, 1 and 2. Always remember, for the Constitution to mention an intricate parliamentary procedure, that also would then take away the essence of parliamentary integrity and independence. That is why they don't. Now, next. Which of the following schedules of the Constitution contain provisions regarding anti-defection? 2nd, 5th, 8th. 8th is languages, 5th is scheduled tribes, 2nd is oaths or something like that. So your option would be 10th, which is very simple, 52nd Amendment 1985. 10th schedule is for anti-defection. The answer would be the 10th schedule. This doesn't even require us to, apply our brains to this. Which one of the following is the largest committee of the Parliament? Now this becomes interesting because what if you don't remember the composition? The Committee on Public Accounts, the Committee on Estimates, the Committee on Public Undertakings, and the Committee on Petitions, Now think about it. Good question. Committee on Public Accounts and Public Undertakings. Both of them are performing a check and balance function, right? So both of them will have similar compositions, 15:7 by the way, right? 15 Lok Sabha, 7 Rajya Sabha. Committee on Petitions will be a separate committee for the Lok Sabha and separate committee for the Rajya Sabha because you're dealing with whatever is being done within that house, intra-separation of powers. You will have lesser members than checks and balances. Whereas Committee on Estimates only comprises of members of the Lok Sabha who assist the government in formulating what their demands should be, what their formulation of financial expectations would be. Now, 2 committees cannot be the largest because they are performing similar functions. You can't give one more members than the other. The only that you're left by elimination is B, Committee on Estimates. Okay. Now, next, consider the following statements. The President shall make rules for the more convenient transaction of the business of Government of India and for the allocation of ministers and of the said business. The President shall make rules for more convenient transaction of the business of government and for allocation of the same of the ministers of the said business. All executive actions of the government shall be expressed to be taken in the name of the Prime Minister. If the President is the executive head of the country, then why would actions be taken in the name of the Prime Minister? The second is wrong. And because the President is the only person who is apolitical, on the advice of the Council of Ministers would you then decide what kind of business should be allocated to whom, and of course maintaining what is the kind of work, what are the kind of ministries, and there are of course limitations on the number of ministers that you can have. The first is correct, second is wrong, so your option is A1 only is the correct answer. 55. Which of the following are discretionary powers given to the governor of a state? Now, sending a report to the President for imposing President's rule, appointing the ministers, reserving certain bills by the state legislature for consideration of the President of India, making the rules to conduct the business of the state government. Now, let us see which of the following makes sense. You've got 1 and 2, 1 and 3, 2, 3 and 4, 1, 2, 3 and 4. Which of the following is correct? Sending a report to the President on whether the situation in the state is bad enough for you to implement a financial emergency sounds like a discretion, because if it wasn't a discretion, then you'll have to listen to the Council of Ministers. And why would the Council of Ministers of a state recommend the governor of their own state that, listen, we have failed and we need help, can you please help us with presidential rule? 1 is definitely correct. If 1 is definitely correct, then this is out. Then you look at reserving certain bills passed by the state legislature for consideration of the President of India. Reserving certain bills passed by the state legislature for concerning is a discretionary power. If the governor feels that a bill must be assented by the President, you can reserve it. A bill which contains alteration of High Court powers must be reserved for the President. And why would the Council of Ministers tell the governor that why don't you take it up to the President? I don't think you're up for it. So the third is definitely a part of it. So 1 and 3 is definitely true. 1 and 3 is definitely true. Making the rules to conduct the business of the state government, right? 1 and 3 is definitely true. Now, discretion means you don't have to listen to the ministers. Now, does the governor not have to listen to the CM while appointing other ministers? Of course you have to, so it's not a discretionary power. Does the governor not have to listen to the ministers before making the rules to conduct the business of the state government? The governor cannot have any rule-making authority because the governor is an appointed office and not an elected one. So you cannot make rules. You're supposed to be bound by the elected offices. So 4 is wrong and therefore 2 is wrong. These are not discretionary powers. The answer is B, 1 and 3, right? Just bring it down to something very simple and you'll be able to answer. The answer is B, 1 and 3, right? Yes. Okay. 56. Which of the following is or are functions of the Cabinet Secretariat? Preparation of agenda for Cabinet meetings, secretarial assistance to Cabinet committees, allocation of financial resources to ministries. Which of the following are functions or agendas of the Cabinet Secretariat? 1, 2 and 3, 1 and 2, 1, 2 and 3. You will see 1, you will see 1 and you will see 2 in 3 out of the 4 options. If we can get some sort of clarity on this, we'll be able to answer this. Now, allocation of financial resources to ministries is nothing but the budget, and this requires a sanction of the Parliament, and a secretariat cannot do that. So any option which has 3 in it automatically gets eliminated. Now you have 1 and 1 and 2 only. If 1 and 2 and only, which means 1 is definitely correct. If you can assist in the preparation of agenda, then can you also not provide administrative support to cabinet committees? Yes, it seems like a natural correlative function. So answer should be C, 1 and 2. Right? That's how you also have the cabinet secretariat service also. The sales tax you pay while purchasing a toothpaste. Now this is a question which is redundant now because of GST. Is a tax imposed and collected by the state government. It's no longer something that you have to worry about right now. Now, the Parliament can make any law for whole or any part of India for implementing international treaties with the consent of the states, with the consent of the majority of the states, with the consent of the states concerned, or without the consent of the state. We know that the Parliament can make any law for implementing an international treaty. You don't even need a Rajya Sabha authorization for the same, because you have ratified an international document, and implementing foreign policy is a subject matter of the union list, and therefore you can do this without the consent of the states. A simple question. Consider the following statements. An amendment to the Constitution of India can be initiated by an introduction of a bill in the Lok Sabha only becomes a trigger word. If such an amendment seeks to make changes in the federal character of the Constitution, it also requires to be ratified by the legislature of all the states of the country. Here, all becomes your trigger word. So obviously you have to read them with a fair degree of suspicion so that we can get this part right. Okay. So an amendment to the Constitution can be initiated by a Lok Sabha bill only. No, both Lok Sabha and Rajya Sabha have equal powers of constitutional amendments. If such an amendment seeks to make changes in the federal character, it has to be ratified by all the states. No, only half of the state legislatures, and that also with simple majority, right? So the answer is both the statements are incorrect. The answer would be D, neither 1 or 2. Consider the following statements. The chairman and the deputy chairman of the Rajya Sabha are not members of that house. While the nominated members of the two houses of the parliament have no voting right in the presidential election, they have the right to vote in the election to the vice president. All right. Let's apply simple democratic mandate. The chairman and the deputy chairman are not the members of that house. That is incorrect, because the deputy chairman is, you are elected from the house through simple majority. The chairman is not a member of the house. The first statement is wrong. While the nominated members have no voting right in the presidential election because they don't have the mandate to do so, but they have the right to vote in the election of the vice president, because the vice president fundamentally functions as the chairperson of the second house, which is a presiding officer function, and all members are equal in the house. Therefore, elected and nominated members both participate. This is the correct option. The answer should be B, 2 only. Let's quickly check if that's the case. Yes, it is. The thrill that you still get to get questions right after so many years is still a good sign. In the context of India, which of the following principles is or are implied institutionally in the parliamentary government? So institutionally, that becomes an important word. Members of the cabinet are members of the parliament. Members hold the office till they enjoy confidence in the parliament. The cabinet is headed by the head of the state. Let's look at option combos. 1 and 2, 3, 2 and 3, 1, 2 and 3. We can clearly see 3 is an option which is common to 3 out of 4 options. Cabinet is government, president is the head of the state. The head of the state cannot be head of the government in a parliamentary democracy, especially in the context of India. 3 is wrong. Any option which has 3 gets eliminated. Your option becomes A, 1 and 2 only, right? Your option becomes A, 1 and 2 only. 62. Consider the following statements. The Parliamentary Committee on Public Accounts consists of not more than 25 members of the Lok Sabha, scrutinizes appropriation and finance accounts of the government, examines the report of the Comptroller and the Auditor General. Now, The Parliamentary Committee on Public Accounts is performing a check and balance function, right? Because it is a public account. So public accounts means how the money has been spent. If you see 1 and 2 options can give you some form of correlative contradiction. If you're examining the accounts of the government and you only have members of the Lok Sabha, and this has implications on the states as well. So it should have members of the Lok Sabha and the Rajya Sabha both. The first statement is most certainly wrong. So any option which has the first statement gets eliminated, which means you have option 2 and option 3. Scrutinizes appropriation and finance accounts and examines the report of the Comptroller and the Auditor General. 3 is definitely correct, 2 and 3 and 3 only. If you're examining the report of the Comptroller and Auditor General and they examine the appropriation made by the government, so if 3 is 2, 2 definitely has to be true. So therefore the answer is B, 2 and 3. Yeah, 63. What will follow if the money bill is substantially amended by the Rajya Sabha? The Lok Sabha may still proceed with the bill, accepting or not accepting the recommendations of the Rajya Sabha. The Lok Sabha cannot consider the bill further. The Lok Sabha may send the bill to the Rajya Sabha for reconsideration. The President may call for a joint sitting of the bill. Now, this is nothing but center stronger than the states, and how the Lok Sabha has more powers than the Rajya Sabha. The Lok Sabha may still proceed with the bill, accepting or not accepting the recommendations. It can also overrule it. There's absolutely no problem. A joint sitting can only happen if there is a deadlock. They don't have equal powers, so there cannot be a deadlock for a money bill. There is no need to send for reconsideration if you have more powers. Because there can't be a deadlock, you can discuss the bill as long as you want. So the option becomes A, which is your correct answer. Okay. Next, 64. Which one of the following statements is correct? In India, the same person cannot be appointed as governor for 2 or more states at the same time. The judges of the High Court of the states are appointed by the governor, just as the judges of the High Court or judges of the Supreme Court are appointed by the President. No procedure has been laid down in the Constitution for the removal of governor from his or her post. In case of a union territory having a legislative setup, the Chief Minister is appointed by the Lieutenant Governor on the basis of majority support, which means whichever party has a majority support and therefore can be chosen, right? Now, let's understand this. Is correct. In India, same person cannot be appointed. Of course, you can have joint governors if you have a smaller state. The judges of the High Court are appointed by the this is incorrect because you can have joint governors, so this is incorrect. The judges of the High Court of the states are appointed by the governor. No, they're appointed by the President. The oath is given by the governor. This is why you have an independent and an integrated judiciary. If they're appointed by a collegium, and the collegium recommends to the President, the collegium always recommends to the President, then the appointment will also be made by the President. So this is also wrong. No procedure has been laid down in the Constitution for the removal of the governor. That is absolutely correct. In the case of a union territory having legislative assembly, the Chief Minister is appointed by the Lieutenant Governor on the basis of majority support. The Lieutenant Governor on the basis of majority support is this on the basis of majority is actually wrong. It's actually not even appointed by the Lieutenant Governor. It is usually appointed by the President. That's a special feature for both Delhi and Pondicherry. This is also wrong. Okay. Now, C. The Council of Ministers in the state shall be collectively Council of Ministers in the centre shall be collectively responsible to the Parliament. The Union Minister shall hold the office during the pleasure of the President of India. The Prime Minister shall communicate to the President about the proposals for legislation. Alright, so you've got 1 in 3 places, you've got 3 in 3 places. The Union Ministers in the centre shall be collectively responsible to the Parliament. No, it is the Lok Sabha, because otherwise you would violate centre stronger than the states. So anything which has 1 in it automatically gets eliminated. Your answer becomes B, 2 and 3, right? You don't even have to think twice about it. The government enacted the Panchayat Extension Act. Which of the following is not identified as its objective? To provide self-governance, to recognize traditional rights, to create autonomous regions in tribal areas, to free tribal people from exploitation. Now, what do you mean by autonomous regions? It means that you have powers to govern yourself, right? It means you have the powers to govern yourself. Now, think about this. Do we create self-governing institutions such as Gram Sabha? Yes, of course we do. What do we, right? So let's understand this is not identified. Now, when we say autonomous, it means you are completely autonomous. You do not require any support, or you do not derive your powers from any external institution. That is not the case, right? Because autonomous regions are actually created in the 6th schedule, where PISA doesn't even apply. There you have your autonomous districts. Here, your Gram Sabhas will get the powers as given to them by the respective legislatures and some additional powers as such. So the answer here will be C. Okay. Next. Under the schedule, this is a tough question but a very easy one actually at the same time. Under the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act of 2006, who shall be the authority to initiate the process of determining the nature and extent of individual or community forest rights, or both, right? To decide both. Now, you are going to decide the nature and the extent of forest rights, an individual's forest right and a community's right to use the forest, right? Now, this is to decide how much of a forest can be used, right? You're deciding how much of encroachment, how much of activity can happen in a forest. Think about it. What is common to the first three? They're all executive. State Forest Department, District Collector, Tehsildar. The only thing which is a legislative entity is a Gram Sabha, and therefore this becomes your correct answer, because you are giving powers to perform a certain activity, right? Are they implementing it properly or not? The rest of the authorities can look into. So that is why it becomes the Gram Sabha. Yep. A deadlock between the Lok Sabha and the Rajya Sabha calls for a joint sitting of the Parliament during the passage of. Where can then be a joint sitting? An ordinary bill, money bill, a constitutional amendment bill. 1, 2 and 3, 1 and 3, 1, 2 and 3. We know you can't have a joint sitting for a constitutional amendment, because if that is the case, then one house will overpower the other. Any option which has 3 in it gets automatically eliminated. You can only have a joint sitting for what is called an ordinary legislation, and for the money bill also you can't, because you don't have equal powers. The answer is A, 1 only. Which of the following are methods of parliamentary control over public finance in India? Placing annual financial statement before the Parliament, withdrawal of monies from Consolidated Fund of India only after passing an appropriation bill, provisions of supplementary grants and vote on accounts, a periodic or at least a mid-year review of the program of the government against macroeconomic forecast and expenditure by a parliamentary budget office, and introducing a finance bill in the Parliament, right? Introducing a finance bill in the Parliament, right? Now, let us see if we can eliminate something. We've got 1, 2, 3 and 5, 1, 2 and 4, 3, 4 and 5. We've got 1, 2, 3, 4 and 5. As we can see that there is at least, we've got 1 in 3 options. We've got 1 in 3 options, we've got 2 in 3 options, we've got 4 in 3 options, and we've got 5 in 3 options, right? Okay. Now, that means it does not make sense for us to look at option combination methods. It's going to be us running around in circles. All right. Now, let us see what doesn't sound okay. Methods of parliamentary control will have to be definite in nature, right? Will have to be definite in nature. So when you place annual financial statements before the Parliament, which is basically the Parliament passing the budget, this is definitely true. Now, Consolidated Fund of India, when you're taking money out of it, is nothing but a money bill, and this or let's say in the concept of budget, it is an appropriation bill. If statement 1 is correct, statement 2 will definitely be correct. So any option which is 1 and 2 will always be true. Provisions of supplementary grants and vote on accounts, they have to also be approved by the parliament in case you need more money and your budgetary money is running out. Makes sense. Introducing a finance bill in the parliament is again fiscal policy decisions which you require parliamentary sanction for. This sounds too vague. A periodic or at least a mid-year review program of the government against macroeconomic forecasts. Macroeconomic forecasts by who? Because 5 different people will have 5 different forecasts. Your macroeconomic forecast by the government is always great, but anything which is not the government is always worrying. So 4 cannot be true. So any option which has actually 4 in it can be eliminated. Your answer would be A, 1, 2, 3 and 5. Look for the meaning of the words. Which of the following special powers have been conferred to the Rajya Sabha by the Constitution of India? To change the existing territory of India and to change the name of the state. To pass a resolution, this is equal powers. To pass a resolution empowering the parliament to make laws in the state list and to create one or more state legislatures. To amend the election procedure of the president to determine the pension of the president. To determine the functions of the election commission and to determine the number of election commissioners. In case you're slightly confused about this, argue the opposite. To change the existing territory center stronger than the states, the parliament as a whole participates, no special power here. To amend the election procedure of the president, why would you give the Rajya Sabha the special powers? The president is elected by both the center and the states. To determine the functions of the election commission, why would the Rajya Sabha get special powers for this? The election commission conducts elections for not only the center and the states, but the president and the vice president as well. What you are left with is option number B, to pass a resolution empowering the parliament to make laws and to create one or more all India services. The answer is B. Yeah. Regarding the office of the Lok Sabha Speaker, consider the following statements. He or she holds office during the pleasure of the president. He or she need not be a member of the house at the time of her election, but has to be a member of the house within 6 months from the date of his or her election. If he or she intends to resign, the letter of the resignation has to be addressed to the deputy speaker. Which of the following statements are correct? Okay. If you're not a member of the house, then you have no business being in the house. If you're not in the house, then the house cannot elect you as a speaker. The second option is definitely wrong. So anything which has second is out. The only option that you're left with is either either none of them are true, but if the person has to resign, the person has to resign by submitting the resignation to the deputy speaker, and therefore the answer is B, because the speaker resigns to the deputy speaker, the deputy speaker resigns to the speaker, right? You can't hold the office of the pleasure of the president because that would violate separation of powers and the democratic mandate of the houses. Yeah. Consider the following statements. Union territories are not represented in the Rajya Sabha. It is within the purview of the Chief Election Commissioner to adjudicate election disputes. According to the Constitution of India, the Parliament consists of the Lok Sabha and the Rajya Sabha only. Which of the following statements are correct? 1, 2 and 3, 1 and 3, none. Alright. What do we know for sure? The Parliament consists of the President, the Lok Sabha and the Rajya Sabha. The President is not a member but a part because you perform certain legislative procedural functions. So any option which has 3 in it automatically gets eliminated. So either 1 is correct or none of them are correct. So union territories are not represented in the Rajya Sabha. Are all union territories not represented? No. Union territories with legislative assemblies are. For example, Delhi has 1 Rajya Sabha seat. Yeah. So Delhi is represented. Delhi is a union territory with a with a legislative assembly. The answer should be D, none. 73. In the Parliament of India, the purpose of an adjournment motion is to allow a discussion on a definite matter of urgent public importance, to let opposition members collect information from the ministers, to allow a reduction of a specific amount in a demand for grant, to postpone the proceedings to check the appropriate or violent behavior of some members, right? Let's eliminate. To let opposition members collect information seems too vague and slightly dramatic. To allow reduction of specific amount in demand for grant is a part of the budget, so this is not even on the same page. To postpone the proceedings to check inappropriate or violent proceedings. Why would the House stop and discuss why was somebody violent? You would usually refer it to a privileges committee. What you are left with is A. The answer is therefore A. According to the Constitution of India, it is the duty of the President of India to cause to be laid before the Parliament which of the following? Recommendations of the Finance Commission, Public Accounts Committee, CAG, reports of the National Commission for Scheduled Classes, right? National Commission for Scheduled Classes. Now, Parliamentary Committee. The Parliamentary Committee that looks into the CAG reports, if 2 is correct, 3 is definitely correct. 2 and 3 are only here together, the answer automatically becomes D. This is the constitutional body. Reports of all constitutional bodies have to be placed before the Parliament because of checks and balances. We've discussed this in the Magna Carta series where we discussed bodies as our last lecture, lecture number 9. According to me, the answer should be D. The answer should be D, but the answer is C. So the Public Accounts Committee's report is not necessarily so. C. So all constitutional bodies. So 1, 3 and 4 are constitutional bodies, and Public Accounts Committee is a parliamentary committee. If the President forces the Public Accounts Committee to channelize, to showcase their report before the Parliament, what you would eventually do is break the democratic mandate, and therefore report of the Public Accounts Committee does not necessarily have to be tabled before the Parliament. CAG, definitely yes. My bad, the answer should be 1, 3 and 4. Okay. 75. The Prime Minister of India at the time of his or her appointment need not necessarily be a member of one of the houses, but must become a member of one of the houses within 6 months. Need not necessarily be a member of one of the houses, but must become a member of the Lok Sabha within 6 months. Must be a member of one of the houses of the Parliament. Must be a member of the Lok Sabha. This is a clear-cut answer. Become a member of one of the houses of the Parliament within 6 months. Why not just the Lok Sabha? Because what if there is no scope for a by-election? Must be a member of one of the houses. If that was the case, then how would Manmohan Singh become the Prime Minister of India? And interestingly, that's what the question has been asked. Must be a member of the Lok Sabha. That's not necessarily true. You get 6 months of lead time. All ministers, including the Prime Minister, are subject to the same criteria. The answer should be A. The distribution of powers between the centre and the states in the Indian Constitution is based in the Morlamento 1909, Montague-Chelmsford 1919, Government of India Act 1935 and Indian Independence Act 1947. I know this can sound slightly confusing, but it actually is not. The distribution must always be done through a law, so it's definitely not Morlamento reforms. Now, Indian Independence Act granted independence to India, so this is not the option. Our larger elements of federalism and centre states are actually originated to the Government of India Act, where the concept of residuary powers, state and central lists, even institutions of governor for that matter, very broad hintages of emergency, all of them have been mentioned in the Government of India Act. So the answer would definitely be Government of India Act 1935, right? C. In the areas covered under the Panchayat Extension Schedule Act of 96, which of the following, which is the power of the Gram Sabha? Gram Sabha has the power to prevent alienation of land in scheduled areas. It has the power of ownership of minor produce. Recommendation of the Gram Sabha is required for granting prospective license or mining lease in any of the areas, right? In any of the areas. Now, think about it. The recommendation of the Gram Sabha is required for granting prospective license or mining lease. Look at our trigger word, for any mineral. Any would mean if you find uranium or titanium, then you will still have to ask the Gram Sabha. Uranium could be a life-changing mineral for the country. It is only for minor minerals. So any option which is 3 will be wrong. So you're left with 1 and 1 and 2 only. You're left with 1 and 1 and 2 only. Now if you think about it, ownership of minor forest produce, that is correct, and to prevent alienation is also correct, so that you can make sure that the Gram Sabha is consenting to usage of land, and minor forest produce such as timber, etc., you can only use through Gram Sabha permission. Okay, so the answer will be 1 and 2 only. 78. What is the difference between vote on account and interim budget? The provision of a vote on account is used by a regular government, while an interim budget is used by a caretaker government. A vote on account only deals with expenditure in the government's budget, whereas an interim budget deals with both expenditure and receipts. A very, very good question. The provision of a vote on account is used by a regular government, while an interim budget is used by a caretaker government. Now, understand this. A regular government, there is no such thing called a regular government. Vote on account is basically the budget has not been passed yet, but 31st March has ended. You need money to run for 2-3 months. That can happen any year of any government in power. So this is wrong. While vote on account is about giving them money to spend, interim budget is about how the money is going to also come, broad projections. So second option is correct, only 2 is correct. So that seems to be the right answer. Okay. When the annual budget is not passed by the Lok Sabha, the budget is modified and presented again. The budget is referred to the Rajya Sabha. The finance minister is asked to resign, and the prime minister submits the resignation of council of ministers. If the budget has failed to be passed, which means the government does not have the confidence of the house in the overall financial policy landscape of the country, which is as good as a no confidence motion, which means the minister has to resign along with council of ministers. Very simple question. All revenues received by the government, by the union government, by way of taxes and other receipts for the conduct of government business are credited to contingency fund, public account, consolidated fund, deposits and advances. So money received by the government for the services that the government is providing, or taxes or any other form of government business, will always come to the consolidated. Public account is public money. Contingency account is emergency money. Deposits and advance funds is essentially the deposits of the government. So your answer would therefore be C, Consolidated Fund of India, right? Yeah. 81. The authorization of the withdrawal of funds from the Consolidated Fund of India must come from the President, Parliament, Prime Minister, Finance Minister. Democratic mandate, the Parliament must authorize it. The answer should be B, Parliament of India. Consider the following statements. In India, a Metropolitan Planning Committee, now this is a toughie, is constituted under the provisions of the Constitution of India. It prepares the draft development plans for metropolitan area. It has the sole responsibility for implementing government-sponsored schemes in a metropolitan area. It is the only one who is supposed to implement government-sponsored schemes, and what is the bureaucracy going to do in urban areas? Is constituted under the Constitution of India, which means the Constitution should talk about it. I don't think it does. So look at options which can be eliminated. It is definitely not under the Constitution. 1 is incorrect. Anything which has 1 gets eliminated. This also seems wrong, because if they were supposed to implement schemes, then what would the district commissioner and the other officials also do? So the answer should be B, 2 only. Let me just check. So 1 is also correct. So I'm mistaken here. The Constitution of India does mention a metropolitan committee. I'm not sure of this, but okay. 83. The Constitution 73rd Amendment of 1992, which aims at promoting the Panchayati Raj institutions in the country, provides for which of the following? Constitution of District Planning Committees, State Election Commissions to conduct all Panchayati Raj, establishment of State Finance Commissions, right? So State Finance Commission is definitely true. It is an essential body that has to be conducted. So any option which does not have 3 in it is removed. So it's either 1, 2 and 3 or 2 and 3. Now let's look at this option and let's see what we can come to a consensus with. Okay. Constitution of district planning committees. Now, district planning committees would mean committees comprising of both rural and urban counterparts, but 73rd largely deals with only rural, so district planning committees does not make sense. The answer according to me should just be 2 and 3. The answer is 2 and 3. All right, done. So these are the 83 questions that have been asked from this area. I know this is a long video, but this will help you revise a week before your exam. And I will see you soon with the rest of the 2 sessions. One is on judiciary and the other is on bodies. These are very small videos because not many questions have been asked. And of course, I will also be releasing the prelims talk of 2022 today itself. Thank you, and always incredibly indebted for your support and your motivation. Thank you.